The Renters' Rights Bill is due to get Royal Assent by the end of October and come into effect in 2026. But do you know what the bill actually says? Because there's so much clickbait nonsense out there on YouTube, social media, and even on industry blogs. But in this video, I help you sort fact from fiction by exposing 10 myths about the Renters' Rights Bill. All of these have appeared in the media or on social media, etc., in recent weeks. And who am I? I'm Suzanne Smith. I'm a portfolio landlord and I worked as a solicitor for 25 years. I produce free, reliable content on the Independent Landlord website and in this YouTube channel. You can sign up for my free weekly newsletter at theindependentlandlord.com/subscribe. Right, let's crack on. Myth number one is no fault evictions will be abolished. We hear this a lot. Yes, the Renters' Rights Act will indeed move Section 21, and Section 21 is often called the no-fault eviction notice. But that's not quite right. It just means that landlords can evict a tenant without having to say why and without having to prove to a judge that they have a good legal reason to do it. These legal reasons are called grounds. However, the abolition of Section 21 will not end the right of landlords to evict tenants when there's been no fault on the part of the tenant. Landlords will be able to evict tenants if they intend to sell up, move in themselves or move in close family, redevelop it, and if they let to students who live in HMOs and they wish to let to another group of full-time students. Myth number two, Section 21 will be abolished immediately after Royal Assent. Lots of people seem to assume that as soon as the Renters' Rights Bill comes into law as a Renters' Rights Act, it will come into force straight away, but it won't. Section 21 will not be abolished when the Renters' Rights Bill becomes a Renters' Rights Act. Instead, Section 21 will only be abolished when the new assured periodic tenancy system comes into force on what's called the commencement date. And the government have said that they'll give the private rented sector sufficient time to get ready for the change.
And we will provide sufficient notice ahead of implementation.
But there'll be at least a few months before Section 21 is actually abolished. It will be in 2026. We don't know exactly when at the moment. Consequently, landlords will be able to keep serving valid Section 21 notices until probably the spring of 2026, maybe even later, assuming, of course, that they comply with all the other requirements that you need for a valid Section 21 notice. And any Section 21 notices that have already been served by the commencement date will continue to be valid so long as the landlord applies to the court to issue an application for an order for possession within 3 months of the commencement date. Myth number three, it will be too difficult for landlords to self-manage. I hear this a lot, especially from letting agents. But for a start, I think this infantilizes landlords, many of whom are more than capable of managing their own portfolio and complying with the various laws. Sure, there are landlords who've been on a course and think that property investing is passive income, or landlords who don't take it seriously. Some landlords don't want the hassle, but there are many landlords who are more than capable of managing their own portfolios. They understand that there's a lot more to self-management than arranging repairs, and they take the time to keep up to date with the latest compliance requirements. It's true that the Renters' Rights Act is complicated, but there's plenty of guidance out there for landlords to follow. Not only will the government put out free guidance after Royal Assent, there's a lot of free content on my website, theindependentlandlord.com. And also, if you're looking for ongoing support, you can join my new membership, the Independent Landlord Hub. Courses come as standard along with exclusive checklists and templates, twice monthly webinars, taking a very practical point of view as well. And you can click through to it on theindependentlandlord.com/hub to find out more. Myth number four, This myth is that landlords will be required to use letting agents. There's a rumour going around about this over the summer. I don't know where it came from, but I've seen it in comments in forums that landlords will not be allowed to self-manage. Now, this is untrue. I might add that letting agents do not currently need to have any qualifications to manage property. Now, it's true that the good ones will have some form of qualification, a level 3 or a level 4, and you should always look out for letting agents who are qualified. But there is currently no legal obligation for letting agents to have any qualifications at all. Myth number 5, landlords will need to pay back rent paid in advance. The bill makes it very clear that the new rent in advance rules only impact new tenancies which come into force after the commencement date, and any rent paid in advance doesn't need to be repaid. The only exception for that is when the tenant has paid rent in advance, but the tenancy ends before the rent has been used up. And in that case, the tenant is entitled to be repaid any part of the rent that relates to days falling after the end of the tenancy. Tenants won't be able to pay rent in advance before they actually sign the tenancy agreement and the landlord signs the agreement. But once it's signed, the tenants will be able to pay rent in advance if they want to. It's just that any clause in a tenancy agreement that says that they have to pay rent in advance will be null and void. It will only be a breach of the Tenant Fees Act if tenants pay rent in advance before the parties sign the agreement, or the landlord or the letting agent asks to do it before the agreement's signed. But if the tenant pays it voluntarily after the agreement has signed, and this means for new agreements after the commencement date, that will be fine. It's just that any clauses in a tenancy agreement that say that a tenant must pay rent in advance, they won't be enforceable. Myth number 6. Landlords should remove rent review clauses from tenancy agreements now. There's no need for landlords to remove rent review clauses from their existing tenancy agreements. These clauses will continue to be valid until the commencement date, which, as I said, is sometime in 2026. And after the commencement date, any rent review clauses that are still in a tenancy agreement will have no effect. They'll automatically be voided and they can be disregarded. And so landlords may well choose to issue a new assured periodic tenancy agreement after the commencement date to remove any clauses that no longer have an effect. But there's no need to delete rent review clauses from existing ASTs now. And these ASTs will become assured periodic tenancies anyway on the commencement automatically without the landlord having to do anything. Myth number 7. Rent guarantee insurance will be necessary to protect your rental income and possible exposure to legal costs. Now, taking out insurance to cover rent arrears and legal costs is a perfectly valid way to mitigate some of the increased risks in the Renters' Rights Bill. However, this won't be necessary for everyone. If you've got a good tenant who pays on time, they've been with you for a long time, the likelihood of the tenant suddenly not paying their rent just because a law comes into effect is highly unlikely. On the other hand, if you have a new tenant, it might make sense to hedge your bets a bit for the first couple of years and take out insurance. As for me, I prefer prevention rather than compensation. And this is why I believe that we should spend more time on choosing good tenants in the first place, not just relying on standard references, but to do our own checks. For instance, calling the previous landlords for a reference yourself. They're far more likely to be forthcoming than the current landlord, who may be pleased to get rid of them. Myth number 8. Rent must be increased by serving a Section 13 notice every 12 months after giving 2 months' notice. I've seen this on LinkedIn. This is almost right, but not quite right. As is the case now with Section 13, the notice, that's Form 4, must expire on the date that the rent is due to be paid. There's a case about this. This means that the landlord will always need to serve the notice a little more than 2 months in advance to allow time for service, unless they happen to hand it over before 4:30 on the working day that is exactly 2 months before the rent is due to change. Also, the crucial point is that The 12-month rule is counted from the last time that the rent was increased using a Section 13 notice. This means if a landlord increased rent by exchange of letters or an addendum outside of a fixed term, then the rent increase will be disregarded. In the future, the clock will start ticking 12 months from when the new rent came into effect after the service of a Section 13 notice. And this will be at least 14 months from the date of service of the Section 13 notice to allow the minimum 2 months notice. I know that's a bit of a mouthful. It may be longer than 14 months if the tenants challenge the rent increase at a first-tier tribunal, as the new rent will come into effect after the judge makes a decision, which might be some months after the tenant challenges the rent increase. Myth number 9. The Renters' Rights Bill introduces rent controls. The Renters' Rights Bill doesn't introduce rent controls. This is because the tribunal will no longer be able to increase the rent, and the date the rent increase comes into effect will be delayed until after the judge makes a decision. Now, this may have the effect of stabilizing rents and make landlords less likely to put up the rent, but it's not the same as putting an arbitrary cap on rent increases like inflation. The government has also been at pains to point out on numerous occasions that it will not introduce rent controls. Myth number 10. Landlords won't be able to insist on a tenant having a guarantor. Now, it's not true that landlords won't be able to ask for a guarantor, such as a parent, to guarantee the rent once the Renters' Rights Bill comes into effect. Landlords will be able to continue to ask a tenant for someone to guarantee the rent. The only change the bill makes about guarantees is the liability of a guarantor will end if the tenant dies. Several MPs, including Carla Denyer from the Green Party, proposed an amendment to the bill to prohibit landlords from asking for guarantors, but it never made it into the bill. However, many people believe it's in the bill because of incorrect information in forums and on social media. With so many myths circulating about the Renters' Rights Bill, it's so important to obtain your information from reliable sources. And if you found this Mythbuster useful, please subscribe to my channel. You can also get extra support by joining us in the Independent Landlord Hub for reliable, practical guidance on how to comply with the Renters' Rights Act and much more. Lots of opportunities to ask questions in a supportive environment. And you can find out more by going to theindependentlandlord.com/hub. Come and join us in the hub and see you soon.